The point.
Hello and welcome. You're watching To The Point. Tonight our focus over the next 1 hour is the government's ordinance amending the Land Acquisition Act. Now you already know that it's met with a sharply polarized response. Industrialists and many economists have welcomed the amendment. The political opposition and several activists are sharply critical. So today in a special program we should examine the many amendments in detail and hopefully ask and answer critical questions. Are the amendments justified? Or is the criticism valid? Hopefully, an hour from now, you'll have a far better grasp of this key issue. Now joining me to discuss the Land Acquisition Amendment Ordinance is the well-known economist and chairman of Oxus Investments, Surjit Bhalla, the renowned activist and fighter for tribal rights, Medha Patkar, the founding chairman and CEO of ReNew Power Ventures, Sumant Sinha, BJP National Executive Member Sheshadri Chari, and Congress MP and spokesperson Abhishek Singhvi. Surjit Bhalla, the ordinance amending the Land Acquisition Act does away with the consent clause as well as the social impact assessment requirement for land required for 5 specific purposes. And they are PPP projects, industrial corridors, rural infrastructure, affordable housing and defense. Now in your eyes, is this a justified amendment or is it designed to benefit a specific class of corporates, and therefore does that make it discriminatory?
Well, going backwards, if you think of a specific class of corporates as a government, then you're making the first mistake in trying to assess, because both government will acquire land and corporates will acquire land. Regarding the second issue, isn't it much better for the poor person, for the poor farmer, for the rich farmer who sells his land, that he actually be able to sell the land rather than be bogged down in this, forget red tape, this is sort of infinite tape that is bound such that no land transactions take place, and we have a land acquisition law which means no acquisitions. Okay. So I don't think anybody is hurt by the process, by the amendments that have been brought into place. This is actually, a lot of it will go into social infrastructure, will go into education, will go into hospitals, will go into roads. Now, unless we maintain that the poor people do not need hospitals, do not need roads, and do not need educational institutions, then you can go ahead and protest against the law.
Medha Patkar, in contrast to what you've heard from Surjit Bhalla, you firmly believe that the ordinance is designed to benefit corporate entities, and I think you've actually said that some of these are particularly close to Mr. Modi. So let me ask you, on what basis do you come to that conclusion, that they benefit corporates and those corporates are pro-Modi?
You see, second question is known to answer to the second question is known to everyone. Well, Mr. Adani earns 47,000 crores in 17 years. Who else but these kinds of big ones, the Ambanis and Adanis, benefit more than acquiring land because they are the new Jamindars. Whosoever they may be closer to, the point is that this particular act ordinance is taking back the land acquisition process to the British legacy of 1894. And Mr. Bhalla is making a mistake when he is equating government projects with the private projects. First and foremost, the British also said that the Land Acquisition Act of 1894 would not be used for acquiring land forcibly for the private companies, private projects. And that is the scenario all over the world. No other country has such act. And this particular act of 2013 brought in by UPA after much of people's protests all over the country did give only the democratic space to the farmers, fish workers, the laborers, the rural India,
and that
which
now
is being knocked off.
That's been eliminated.
Yes, eliminated.
Mr. Chari, you're nodding your head in disagreement. How would you counter what you've heard from Medha Patkar?
No, two very quick things. You know, ironically, the very first act brought by the British, it is not just 1894, it is, the first act was 1824. The original act is 1824. And in 1824, the Britishers said the same thing. They said, we want to bring this act because we want to create electrification, railway and so many other things. But that apart, you know, there's one small thing. you mentioned defense and other things also. National security is one more issue that has been included here. And national security and also situations created
what
by
about the point
by
Medhaji
war,
makes that
created
the
by war
beneficiaries,
or-
but
Yes.
what about her point?
No.
The beneficiaries are the Adanis who are deemed to be close to Mr. Modi.
No. You know what happens is, after this ordinance, what has now happened is, all the land acquired by this, under this act, these 13 acts which come under it, I'll read out just quickly.
No, we know
National
that.
Highways, Metro, even Atomic Energy Act, Indian Tramway Act, Railway Act, Ancient Monument, all these acts. Now, if government acquires land, there was no compensation.
Mr. Chari, what you're forgetting, can I interrupt you? What you're forgetting is under those heads, Mr. Chari.
Now you get compensation, you get rehabilitation is assured, and resettlement is
Mr.
assured
Chari,
because
what
of
you're
this
forgetting
ordinance.
is that many private companies can acquire
No,
under
you
those
can't.
heads.
You can't. No. Only under PPP if the land is vested in the government.
No, you're wrong. Forgive
It is
me.
there.
You're wrong.
It is there.
No, Mr. Sumant
Under
Sinha-
PPP.
No.
Under PPP.
No, Mr. Chari, not
Only-
just under PPP, private companies operating in defense can
They
acquire
have to
land.
go to, no, they have, no, the government
And
has
they're
to acquire.
excused.
Sir, you read the act.
I have.
The land has to be vested with the government.
That's for PPP purposes.
No, even
Mr.
for defense.
No, you're wrong on that, but let's not
No.
quarrel over that. Sumant Sinha, let me bring you in. The original bill of 2013, which has now been amended, required 70% consent for landowners for PPP projects and 80% consent from landowners for private companies. Now, after the amendment, if private companies are involved in defense, rural infrastructure or affordable housing, or if private companies locate themselves in industrial corridors, they won't have to abide by the consent clause and they won't have to abide by the social impact assessment clause. So clearly, in those 5 areas, private corporates will benefit. Leave aside whether they're close to Mr. Modi or not, but they will be beneficiaries in those areas. Would you accept that?
I would accept that in the context and relative only to the last Land Acquisition Act, which by itself was not necessarily a very robust act to facilitate further investments by the industrial sector. So I think relative to that, I agree with you, this act has facilitated a little bit more, but I think in the absolute sense, if you ask me, I think even this act is fairly onerous because it only excludes 5 or 6 different sectors that get this preferential treatment. And there's a whole host of other manufacturing industries that do not get that benefit, and where in fact the land acquisition process will still be 4 or 5 years long. So to that extent, if you ask me, I even think that this ordinance does not really fully do justice to what really is required to be done from a land acquisition standpoint, from the industrial standpoint.
In other words, as an industrialist, what you're saying to me is that in fact you need further amendments if you're really going to make land acquisition easy for industry and create the grounds for manufacturing, make in India, etc. This doesn't go far enough. You're actually saying that, aren't you, Sumant Sinha?
That is absolutely right. That's what I believe, because at this point in time you've only got these 5 sectors in which you can actually go through a slightly faster process, and in almost every other sector, the steel, any other metal manufacturing, anything else. For example, if you want to set up a semiconductor factory, you want to set up a solar manufacturing area, all of those will have to go through the much longer land acquisition process. And so there are so many other businesses where in fact this ordinance will not really help them.
Come back, Abhishek Singhvi, to the original point that in these 5 areas where in fact the consent clause and the social impact assessment clause is exempted, private companies could benefit. Now, the truth is, practically each of these 5 areas, defense, rural infrastructure, affordable housing, are areas that benefit the economy. Industrial corridors does so particularly. Defense, in addition, benefits national security. So if private companies, by operating in these specific areas, end up getting benefits themselves, so what? They're providing a national service in return. And remember, what the Act does is not make it cheaper, it simply makes it easier to acquire land. Otherwise, industrial development could be impeded. How do you counter that point?
I think we are completely jumbling up the perspective, Karan. There is no need to amend the 1894 Act. In fact, thank God for small mercies. The previous speaker said we should go back to the 1824 Act perhaps. Why have we amended the Act? To make it more difficult to acquire easily, but to give proper balance to the rights of the landowners. Now you raised the very specific question of consent clause and social impact assessment for 5 areas. Do you have in this act before you, Karan, any definition of what an industrial corridor is? What a PPP is? Today a hospital, a road, a metro, educational institution, a convention, a bridge, a convention center are all PPPs. Now today, why do you make an escape clause without definition, which brings you to even identical 1894, then why do you have an amendment at all? Why do you have a new law at all? Do you know, Karan, that an industrial corridor from Mumbai to Delhi
Can I stop you?
Just one second.
Let's not jumble up all the points together. I was asking you about private companies benefiting. Stick to that. I'll come to the others one by one. Otherwise, audiences won't understand.
I am saying the private company benefit. First of all, Mr. Sinha is completely wrong in suggesting that, or Mr. Chari is completely wrong in suggesting this doesn't apply to private companies. It applies, it is meant for them, it is created for them. That's the first point. Secondly, it gives an exception, supposedly in 5 areas, which swallows up the rule. Today, an industrial corridor, it is estimated Delhi-Mumbai, has a square kilometer area of 4.5 lakh square kilometers. The whole thing is out. A PPP is what? Have you defined it? Anything and everything is the PPP.
Well,
so
okay.
These 5 areas will swallow up the rule completely.
Okay, let me stop you there. I want to take these one by one because I think it's important for the sake of the audience who are otherwise befuddled by technical subjects that we take it one by one. Otherwise we'll confuse them and this program will serve no purpose. Let's first, Sujit Bala, look at one of the exemptions, which is in fact hereafter under the new amendments, multi-crop irrigated land can be acquired for these 5 specific purposes. Previously it couldn't. Now many people feel this is going to have a direct impact on Indian agriculture, and more importantly it will have a direct impact, and an adverse one possibly, on the interest of farmers. Do you think that this is one exemption that should not happen?
You know, this is a classic example. I'm glad you brought this up as to how, if you will, confused and polemic the debate is, and we get into obfuscation by lawyers and everybody else. Let's take this issue of whether you can acquire double crop land. Well, all of Indian agriculture, you know, back in the 1930s and 1940s, it was a case that you didn't have double cropping on most of the land. Then came the high yielding variety revolution, and now it is a case that all the land in India, perhaps maybe some land on top of a mountain, that is not double cropped. Everything is double cropped. So what the old Congress ruling had in effect was that you cannot acquire any agricultural land. Forget anybody benefiting. You could not acquire land. In the name of the poor are not benefiting by the old Congress law. So therefore this is an absolute necessity that you at least have some transactions take place. Why don't you ask the farmer whether he wants to sell the land rather than you stipulating that if it is double crop you can't sell the land? I mean, this is absurd.
Okay, Mr. Thapar, you're one of the people who actually has objected to this particular exemption and amendment in particular. And let me put the opposite case to you. Most of Bengal qualifies as multi-crop land. If multi-crop land cannot be acquired for industry, industrialization in Bengal will virtually stop. Therefore, if you're going to give people a better livelihood by providing industrial jobs and providing them an opportunity to move from rural to urban, then you have to have this exemption and multi-crop land has to be acquired.
Karanji, first of all, let me correct the factual errors in many presentations. I think the Act should be read properly. The section 2 of the definitions of infrastructure, which comes from the Department of Economic Affairs, includes manufacturing industry. Mr. Sinha may be happy to hear that. But point is that infrastructure covers electrification to water projects, to manufacturing industry, to tourism, and also the housing for the poor includes the builder-prone housing schemes of the various governments. Second thing
I'll just stop you. So what you're saying is that the point Mr. Sinha made that the Act doesn't go far enough is not true. Your interpretation of infrastructure proves it does. Okay,
yes.
Come to your second point.
Infrastructure will include this Delhi-Mumbai industrial corridor with 3,90,000 hectares targeted in the first phase itself.
Come now to the point I made about multi-crop land.
Yes. But now what is it that they are acquiring land for? The private company word is replaced by private entity. So even if it is a private education institution, no one says that we don't need that.
Let's take this one at a time, otherwise we'll confuse the audience.
No, but
stick first to my point. I'll come to private institutions and hospitals in a moment.
Okay.
Answer my point about your objection to multi-crop land being acquired. Why do you not accept the Bengal argument that if you do not let multi-crop land be acquired, you won't have industrialization in Bengal?
I think Sujit is wrong on this point. It is for the food security purpose, not only of the farmers, but everyone else who eats food and not chemicals or power, requires that the agricultural land, not only multiple crop agricultural land, to be saved. And it is not 100% even today. It is 20-25% at the most in each state. Also, there is lot of, in Maharashtra, 80,000 hectares of land acquired and not used.
Okay.
So why should industry not be, complementary to agriculture, where there is more of livelihood opportunities than the industries or SEZs give us?
Let's move.
Out of 491 projects, 51,000 hectares of land, 40% of the land has been used. The rest of the 60% of the land which is being now put to industrial use was all under the earlier act. Therefore, these figures are wrong. Number one. Number two, as far as putting land to use is concerned, it's not only land acquisition, it is also capital formation, labor laws, infrastructure availability, water, power,
and why do you require the agricultural land?
Other things are equally involved in this.
What you're arguing, in fact, that multi-crop land, please let him answer. Let's do it one by one so audiences can follow. You're arguing that in fact multi-crop land must be made available for acquisition, otherwise industrialization in states like Bengal will stop.
The Act doesn't say multi-crop land must be made available. It only says
it can be acquired.
It can be.
Absolutely.
But when at the time of acquisition, what is to be determined is it for a purpose which is of greater public use and utility, or is it going to affect?
Impact clause has disappeared. Mr. Chari, you're getting confused. I'm stopping you. You're getting confused.
Multi-crop and two crops are again different.
No, Mr. Chari.
We don't have the figures.
Mr. Chari, I'm interrupting you because I'm afraid the social impact clause has disappeared in those areas, so they will not
only in these areas. Only in this.
That's what we're talking about. But that's what we're talking about. We're talking about these areas.
No, only in this area. Number one. Number two.
Mr. Chari,
the most important aspect is these areas did not give any compensation or rehabilitation earlier.
No, Mr. Chari, you're confusing things. Forgive me, you're confusing things. You're confusing the 13 acts that are amended with the 5 specific areas where exemptions are given. You're running the two together.
No.
Yes, you are. Forgive me. I'm moving on. I want to move on and put another concern that's been brought up to you, Sumant Sinha, and it's a critical concern, and it's to do with the fact that unfortunately the term industrial corridor is not defined. As the Business Standard in an article on the 7th of January pointed out, taking the example of the Delhi-Mumbai corridor, this one corridor is 1483 kilometers long and it has a band on either side of 150 kilometers. Altogether, the industrial corridor along this particular route will be 444,900 square kilometers. If you have 5 or 6 such industrial corridors, it's been estimated you're talking about anywhere between 10 and 14% of the entire land area of India. Now, is it justified that in such a vast swathe of territory, the social impact assessment clause and the consent clause should be waived? Because doesn't it then make a mockery of those clauses altogether?
No, I think that what the government has done is that it's given itself flexibility in terms of trying to make more land available for industrial activity. Now, I think we have to debate one issue, which is industrial activity always an antithesis to what India needs at this point in time in terms of further economic growth? The question is, if in fact an industrial manufacturing activity comes up somewhere, it actually does provide jobs to everybody in the neighborhood. It does create further economic development. So why do we have this belief that just by virtue of acquiring land, somebody is going to get so badly dispossessed that ultimately it is going to result in a much worse scenario?
Can I answer that?
I think that is something that we also must debate.
Can I answer that? You see, the concern that arises when the social impact
please.
clause is exempted is that you've undermined the key principle of prior informed consent. And the second concern that arises when the social impact clause is exempted is how do you then work out the compensation due to non-landowners? Now, both of those were integral parts of the original act. Both now, by exempting the social impact assessment clause, have been severely undermined.
No, that may be the case, Karan, but at the same time, I think how the social impact assessment clause would actually operate would in fact increase the time taken for land acquisition by a considerable amount, and also put further approval powers in the hands of various government entities, and that then you have to then take a decision whether you want to actually encourage industrial activity, because if this whole social impact assessment takes 4 or 5 years in terms of the sort of extending the land acquisition process, then you might as well tell industrialists that there's no point in actually putting up anything, because nobody is going to plan a project for where land acquisition takes so long.
You know, that's a very fair point.
So I think this whole concept has to be reworded and redone in some very fundamental manner.
You know, that's a very important point, Abhishek Singhvi, made there by Sumant Sinha. And I imagine he speaks for probably all Indian industrialists who need land to set up their manufacturing plants. The original act made the process of acquiring land so cumbersome, so bound up with red tape, and so determined by the obstacles that lie ahead, that land acquisition became a problem. Now, maybe the government with their amendments have gone the other way, but clearly there's a crying need for a sensible, practical middle ground. Would Congress at least accept that you tied up industrialists in knots because of the number of cumbersome, prolonged procedures necessary, not just for the consent clause, but much more importantly for the social impact clause?
It's an important question. Let me answer it, Karan. Virtue always lies in the middle. Each extreme is always a vice. Now, the real issue is that if there were tailoring changes, changes arising out of experience, minor changes, changes of time period limitations, you could put a limitation that you must complete acquisition so much time, etc., etc. If there would be no problem, it would be open to discussion. Of course, your bypass discussion is not given us a chance, and I am sure as a responsible opposition, the Congress would have partaken in that and agreed to it. The real point is the point you made a moment ago, which is that the heart and soul of the act is taken away in the name of an amending ordinance. You are having here, everything which you have read is being treated by my esteemed colleagues who talk of obfuscation by lawyers, obviously greater obfuscation by non-lawyers here, as a bar, as a prohibition. These are very superficial and shallow arguments. You could simply have a regulatory model.
Can I stop you? Can I stop you?
Put a time limit.
Tucked into your long answer at the very beginning was a willingness to meet halfway, if I understood you correctly. Are you saying to me that Congress would be happy to sit down with the government and say, look, there are some amendments necessary so that the cumbersome, prolonged and endless nature of the social impact clause is reduced, so that it doesn't become an obstacle to land acquisition, but please don't eliminate it. Are you prepared to take that route?
Unfortunately, what you say, Karan, would have been possible had the approach been different. You now have an act which is complete change.
You don't have an act, it's an ordinance.
Yes, you now have an act. At the time being, it's an act because the ordinance is the act. You have, without discussion, without an approach, without reaching out, without any of the things which you said, a done deed. This can't be done like this. Yes, if you come back to the original and come to us by saying that, look, of course we are open. This tailoring is required. This patching is required. Somebody said, you stitched a whole new crop.
You made your point.
You haven't come for, tailoring purposes.
You made your point. Let me bring in Mr. Charlie before I take a break and come to other critical amendments that I want to discuss. There is half a hand being put out by Congress to try and establish a middle ground on this important issue of the social impact clause and the consent clause. They concede that it's a prolonged, obstructive process, but they want to retain it in a diminished form. Are you prepared to meet them halfway?
No, Congress is one of the stakeholders, but Congress is not the only stakeholder. We have to also ask the industry and other departments. We have also to take those. I mean, we cannot divide between development wallas and anti-development wallas. So there has to be a consensus evolved on this. even on the social impact assessment issue. But if a consensus has to be evolved, you have to evolve the consensus from what is available now, rather than going back
What's
to what
very
was not
interesting is that there's half a hand hesitantly held out by Congress, but not really fully, and there's a half hand from you not really held out at all because you believe other people have to be discussed. So there's a scintillating possibility of some sort of compromise, but it's only that and nothing more. It's probably more misleading than real. Let's take a break and come back and consider some of the other critical amendments, and in particular the clause that says that land that hasn't been used for 5 years now does not necessarily have to be returned, as well as the clause which permits acquired land to be used for private educational institutions and hospitals. Are those valid amendments, or are they unjustified?
Live Pure, Aroka expert presents To The Point. Live Pure, Aroka expert presents To The Point.
Welcome back to The Point, and a special discussion about the Land Acquisition Act amendments. Are they justified or are they unwarranted? Sujit Bhalla, let's come to another amendment in the ordinance. It's amended the clause which says that unused land will be returned after 5 years. Arun Jaitley, in his justification, says that projects like cantonments, smart cities, nuclear installations, highways, dams take far more than 5 years, and if land has to be returned after 5 years, then India will become a nation of incomplete projects. Now, before we come to debate that, as an economist, tell me, how critical is this amendment and how serious is the problem that it would seek to address?
Look, the entire thing, in my opinion, has to do with the ease of doing business. You know, we make such a big issue of the fact that India is ranked one of the lowest countries, one of the worst countries of doing business, where business is any activity. Now, here is the Land Acquisition Act, and if you will, this amendment in particular goes ahead and says that, listen, once you've acquired the land, you don't have to return. Can you imagine the kind of, I don't even know how this came in, that after 5 years I got to return the land, then I got to repurchase it, then I got to go through social impact. I mean, this is, you know, I want to ask a very simple question. How many, and Karan, you should do a show on this, how many countries in the world, there are 204 countries, how many countries in the world have this kind of a problem? They all face this issue. We're not the only people in the world with poor people, with not fair compensation, with fat industrialists. How do they cope? Why don't they have all of these nonsensical problems?
Well, let's take one of them.
Only in India, these are major issues that prevents action from taking place.
Let's stick to one of those problems. Let's not bring all of them in together, because that only confuses. On this question of land not having to be returned after 5 years, Mehta Patkar, can you accept Arun Jaitley's argument? After all, you know that dams, highways, nuclear installations, defense cantonments take much more than 5 years. In India, where things are slow, they probably take 15. If the land is returned, right, you'll have an incomplete project, a waste of time, a waste of opportunity.
Point is, the period that a project would take needs also some kind of assessment to be done. They decide and then they agree. Is not possible anymore. The farmers, the fish workers now know that they retain the land without use because of the real estate market. And then they get multiple times the income from the land itself.
Can I interrupt you there? The actual amendment says that in fact the land will be retained for the time believed the project will take, which has to be specified, or 5 years, whichever is later. So you can't retain it for real estate investment purposes for an untime-bound period. That is not possible.
That is what was the process of social impact assessment. It would have given various options to the Gram Sabha, and mind you, that was not very radical. It was not fully in the hands of the Gram Sabha. That options would have been considered by the expert committee also. Jairam Ramesh was always saying that we, the activists, did not agree fully with the act as an ideal act, so there was already a win-win situation. Mr. Chauhan from the Madhya Pradesh government had already suggested irrigation projects to be out. So many amendments which had gone through the act in the first place when the parliamentary committee, Manishankar Iyer, Sandeep Dixit, but also Sumitra Mahajan, Kalyan Singh, all of them had approved unanimously. Why these amendments after such a long period? And for whom do they want to make it easy?
Can I put your central concern to Mr. Chari? Mr. Chari, the central concern that Medha Patkar has is that if land has to not be returned after 5 years and can be retained till whatever period is deemed necessary but specified for a particular project, then there is through the back door a possibility that land will be acquired for real estate purposes, retained to such point till it can be sold off. Can you give an assurance by making that particular amendment more specific, by actually writing it in, that you exclude that possibility completely?
Yeah, specifically on these 5 years, we can relook this also and put certain other clauses which will bind and which will remove all these anomalies, probably. But, starting a project within 5 years, commencement of the project and completion of a project within 5 years are two different things. If a land is taken and the project is not even commenced for 5 years, that's a serious error. But take projects like Udankulam or Tihiri or even Damodar Valley Corporation. It's an ongoing process.
Sure. Let me put to Sumant Sinha the first part of your answer. You heard Mr. Chari say, as a member of the BJP National Executive, that it's possible for the government to add phrases or clauses to this particular amendment so that it's not abused even through the back door, to preclude the possibility that land acquired for a particular project can then be somehow used for real estate investment purposes. Do you accept that that would be a sensible assurance to write in, or do you think that it would put off industrialists because it would worry them that in fact if a project gets delayed, which sometimes happens, they'll end up losing the land?
No, I think that's pretty fair, Karan. I think as long as the safeguards that are built in are fair and if the land was acquired for a certain purpose and there are delays around that project, I'm sure that those can be condoned. But if that land was acquired for a certain purpose and it's going to be used for something totally different, as in, let's say, real estate investments, then certainly that is something that I don't think anybody would condone. And I think those kind of situations, if the government wants to address, then I think industry would be quite okay about those things.
Now, Abhishek,
but I think underlying all of this, there is, the fact is,
Carry on, please finish.
See, the reality is that ultimately how much of India's land would be required for, let's say, industry over the next several years. I would hazard to guess that it's actually a very, very small percentage. So we're actually talking about a fairly small problem as far as India's total land mass is concerned. And even the industrial corridor that he talked about, if they could take 15%, they don't cover 85%.
Okay, we seem to be having problems with your phone line at the moment. We are having problems with your phone line suddenly. Give us a minute, hopefully they can correct it. I'll go on to Abhishek Singhvi and take up with you, Abhishek Singhvi, the point you were making, and you were objecting to it earlier, that acquired land can now, after the amendments, be used for private educational institutions or for private hospitals. Now, earlier, that wasn't possible. But Arun Jaitley says that if you don't permit acquired land to be used for private hospitals and private schools, then you'll end up in a situation where the townships and the smart cities that the government envisages creating will only have government schools and government hospitals. And that's not an acceptable outcome, surely. So would you not accept that this is a lacuna that the amendment correctly takes care of?
Firstly, Karan, I think it's bizarre to interpret the old law to suggest that a land acquired for purpose X after social impact is not used, is substantially used, largely commissioned, and yet it will be returned in midstream. So while this phrase of unfinished projects is a nice one-liner, it's superficial and shallow. The old law nowhere says this, no court can say
Why
this.
is it superficial and shallow? The law clearly says, as passed by your government, that if the project is not finished in 5 years, it will be returned.
It doesn't. You see, if you have a land, you take a land and you have largely done the project, it's mostly complete, The commissioning is back and forth.
No.
That's not to be taken back.
No. What you're forgetting, I hate to interrupt you, but what you're forgetting is that take the example of a cantonment. A cantonment is spread over a sizable area. Not every project on that cantonment premise happens together at the same time. You go in stages. 5 years are over and you may not have even got to stage 2. Suddenly you lose the land that's available for stage 2, 3, 4 and 5.
No, the law nowhere says that first of all 5 years is counted from each part of the cantonment acquired.
Well,
secondly, you don't say anywhere. 1 minute. Let me complete, please. It's an important legal issue. You can't just say, obfuscation by law. It's a law you're discussing. Secondly, if the cantonment is complete, let us say one part of it is complete. The other part is yet to be halfway through. Nobody is saying return it after 5 years. That's a completely shallow interpretation of the law. This is meant, as you said,
the example I was quoting was specifically given, in fact, on television by Arun Jaitley. And therefore, that's one lawyer's interpretation against another lawyer's interpretation. And once again, that suggests if two lawyers can differ over the wording of a clause, the clause needs to be cleaned up.
No, it doesn't need to be cleaned up by saying that you have no 5-year limit.
Okay.
This is meant for unutilized areas.
That's your interpretation.
This 5-year clause is exactly what I also said. Commencement of a project and completion of a project are two different things.
Yes.
I can understand if the project is not commenced at all for whatever reasons, that you look at it from a different point of view. But here, if by the earlier law,
it's very interesting. I'm going to point out for the sake of the audience, just a moment, Abhishek Singh just said, I'm going to point out for the sake of the audience that although prima facie, it seems to them as if Mr. Chari and you are saying the same thing. You're actually saying it with different purposes in mind. Mr. Chari made that point to say it was necessary to have this amendment. You're making the point to try and prove the amendment is not necessary at all because it's already taken care of. So you may agree on the point you're making, but the reasons you're making it are polar opposites. Let's leave it there because I don't want to confuse the audience on this tricky technical issue with details that will become befuddling, and it's already becoming a little tricky to follow. Let me come back to the original question I put to Abhishek Singhvi, which he didn't answer, which is the fact that land that's acquired can now be used for private schools and private hospitals. Earlier that wasn't possible. Would you accept that's a sensible amendment?
It is sensible because today's private educational institutions are also owned by the education mafias. They earn huge through capitation fees and others income, and they are not really only charitable institutions. So why can't they buy over the land and then make their business? Anyway, it is to make business easy.
So hang on,
but those who are not in business...
You are making a very important point. This is one amendment made by the NDA government you agree is sensible. That's what you said.
No, I don't agree. That
you said why shouldn't
include every private entity as an entity for which the state will forcibly acquire land is not necessary.
So no, but come back to my point. Should private educational institutions and hospitals be allowed to use acquired land? Say yes or no.
No. They can buy the land.
But yes, they can buy the land.
Got land.
But they have to buy the land. They have to buy the land.
No. Here now the private entities are also included in the public purpose projects where the state can acquire land.
I'm not sure of that. No, I don't think you're right on that. I don't think you're right on that. No, it's simply that land that is acquired can be used for these purposes. It's not one of the 5 areas where the social impact assessment or the consent clause is exempted. You're confusing the two.
Karan, let me clarify.
I'm going to lose Mr. Sinha. Let me go to him, then I'll come back to you.
But the acquisition will be there. Even if there is social impact assessment, earlier there was no forcible acquisition.
But are you then saying to me, Mrs. Patkar, that in fact you can't acquire land for private schools and hospitals? Then you don't have private schools.
Forcible acquisition should not be there.
Forcible is not there.
It's not there anywhere, either in the earlier law or this law.
Forgive me. This is not one of the 5 exempted areas. No, let's not get lost in detail.
I'm clear about my legal interpretation.
Sinha, let me put this to you. The key concern that many activists have, and it's a very sincere concern because they work at the very cutting edge of the poor and the tribals, is that what this set of amendments does, certainly in those 5 exempted purpose areas, is it makes possible forcible acquisition. And that's clear because the consent clause is exempted and then the social impact assessment clause is exempted. And they don't like the idea, no matter how sacred those 5 purposes may be, that suddenly forcible acquisition becomes possible. They say you're going right back to 1894. Now, can you understand that concern?
No, I can certainly understand it, and I think, look, I think industry has no reason to have a situation where you set up a plant, set up a manufacturing entity in an area where people around you are extremely unhappy with you. So I think that is something that most industrialists or most business people would also be very concerned about. So I think the reality is that we want to do whatever is fair, and I think however the government goes about doing it, whichever sort of processes it wants industry to follow, we are happy to follow that. The only thing is give us visibility that within a certain defined time period, in whatever is the process that is set out, that we're able to acquire land.
Okay.
And that it should not be in such a way that it leaves a lot of discretion in the hands of the government or some government entities or even some local entities for that matter, because you never know. The reality is very often local elements start extorting, start blackmailing as well. Okay. And those things will then just set back everybody.
Okay,
so I think we have to find a way, perhaps whether this ordinance is,
I accept the point you're making, that you want ease of land acquiring, but you don't want any unjustified benefits going to industry. You're not looking for cheaper land. You're not looking for unfairly acquired land. You're just looking for an easier way of doing it. But let me raise that point and put it like this to you, Surjit Bhalla.
That's right.
When you remove the consent clause requirement, okay, and I'm talking about that specifically, not the social impact clause, in industrial corridors, where any type of company can come up, and those industrial corridors could cover vast swathes of the country, but leave that a point aside. Any company can come up. Then is it fair that you have effectively forcible acquisition for private companies in industrial corridors? And remember, that would be any type of company, whether it's deemed to be a socially beneficial company or not.
Yeah. First of all, I don't believe somebody is deemed to be socially beneficial and somebody is not. So, correct phrasing, any type of company. So, correct question. Now, the point is that if you do not allow, remember, and it's very important for the audience to know, it's not as if you're forcibly acquiring land and people are not being compensated. The farmers are not being compensated. Again, I want to emphasize this is a problem faced by all societies.
But it's not compensation I'm talking about. It's the fact that the farmer may not have a choice. That's the point I'm making. He's compensated. No, exactly. He's compensated four times in rural land. But what happens when the farmers do not want their land to be acquired? Forcible acquisition in industrial corridors for any type of company is possible. Is it right?
And there is this example of somebody in China who didn't want to sell the land on part of the middle of a highway, so the government did build the highway on both sides of the land.
We're not talking about highways, we're talking about industrial corridors where any type of company can come up. Let's say it's a battery manufacturer. Why should forcible land be acquired when farmers don't want to sell for a battery manufacturer?
It is, look, as
not just companies.
I think we are raising, I think it is raising a concern to...
all you're trying to do is to make...
Go ahead, finish your answer.
Allow the process of development to take place by having,
that's a generous
if you will, if you allow all of these areas, you have to go through a social impact assessment, you have to go through various other loops before you can acquire land. That is why no land has been acquired under the new law that the Congress had for the last 3 years.
The new law only came into operation in December 2013. It's been barely a year and a couple of months. Let me put the point that's being answered by Surjit Bhalla to you. Surjit Bhalla is saying that you need a process whereby development can go on. And that is clearly the argument that Mr. Jaitley made when he said that this is a way of facilitating what he calls 21st century development needs. But I put something else to you. In industrial corridors, any type of company can come up. Battery manufacturers, right? Now, if you can have forcible acquisition for a battery manufacturer, is it justified? Why should the right of the farmer who says no not take precedence? You're giving precedence to the right of the battery manufacturer in those corridors.
It's not just the farmer, because once the land is acquired in an industrial corridor and given over to some company, either in the PPP model or in any other model, it's not just the farmer, but there are other departments in the government also, and the government is sensitive on all these polluting and non-polluting industries. Any
but you're
polluting
bringing in
industry
different concepts of polluting.
cannot be brought in. And if the government of the day, it is pointed out, and there are enough cross-checks and balances, not only within the law but also within the society. The civil society is also very strong, and no such thing would happen.
Let's put those points one by one very quickly to Abhishek Singhvi and Medha Patkar. What you're hearing, Abhishek Singhvi, and give me a quick answer, is that there are enough checks. He says, Mr. Chari, within the law. To be honest, I don't know what those checks are. I haven't found them. And there are also enough checks within society, but he hasn't specified what they are, that will ensure that the wrong type of forcible acquisition within industrial corridors won't happen. And therefore, my example of battery manufacturers getting precedence through over farmers who don't want to sell is an unrealistic example. A quick answer.
Single check, Karan. The checks were in the law, which has been now amended. The word is amendment. It's actually repealed out of existence because the soul has been taken out. If you add up industrial corridors with any kind of industry, outside of industrial corridor, a 10% stake by the government makes it a triple P. You can have full forcible acquisition. Karan Thapar doesn't want to sell his land. A battery manufacturer in a corridor with zero government participation, outside a corridor with 10% participation, will have precedence over the farmer's right, plus the non-owner nearby will have no right to say. That's the practicality of it.
Let me, I'm stopping you. I'm running out of time. I want Medha Patkar to have a chance.
Any industry is not a blanket.
Mr. Chari, you've made your point. Let Medha Patkar answer. Medha Patkar, I want to put the opposite to you. I know that instinctively you will defend the right of the farmer and give the right of the farmer to refuse precedence over the battery manufacturer. However, let me put this to you. Battery manufacturers create jobs. Any type of company creates jobs. The one thing India needs, the poor need, are jobs. Jobs bring money, money gives livelihood, livelihood gives you a chance to lead a better life. That's what Indians want. Now, by ensuring that you have no consent clause in industrial corridors, you're guaranteeing industry, jobs, improved livelihood, and therefore a future. Why do you resist all of that?
That's just a presumption. The CAG reports tell us that that doesn't necessarily happen even in the special economic zones. But my point is that the Delhi, Mumbai or inner other industrial corridors don't just bring in industries. They bring in the shopping malls, airports, roads, real estate development, all of that is included.
Don't they create jobs and don't you need roads?
It is not necessary.
You don't need roads?
So if that is true, and if they are going to absorb the farmers into those jobs, which has not happened in the Narmada Valley, which has not happened anywhere else because they reserve the land, they don't give land to the ousties, they reserve the land for the corporates. So water, public sector, infrastructure, everything flowing to them. So if they are sure of that, why are they scared in going to the people and giving them a democratic opportunity? The people, if they realize that they are also getting a share in the benefits, they will surely agree to that.
Right.
That is what they are not sure.
It's a very too pessimistic a view of all these development aspects. I think one needs to be very positive. One needs to be very positive.
You're taking the words out of my mouth. Let me say that in fact what lies at the very heart of the dispute over this whole land amendment is the fact of trust. The government is not trusted by the opposition or activists. Industrialists are suspicious that in fact the processes that would ensure a fairer mechanism for farmers would actually impede development. Neither side believes that the other is honest about its objections. Both believe that their real intention is something else. It's the absence of trust that vitiates this debate badly. And I fear that it will resurrect itself hugely when Parliament sits down to pass the act that has to replace this ordinance. The absence of trust is what is really holding up the acquisition of land. That's my personal conclusion, but I'm pretty sure that's the right conclusion from the different opinions we've heard. My thanks to all my guests for joining me, and if you have been, thanks for watching, and I hope this episode has aired some of the differences and brought some of the issues into better, sharper focus. That's it for me. Good night. See you on Monday. Have a great weekend.
Live Pure, Aroka Expert presents To The Point.